Okay, so thank you everybody for being here today with us. This is a workshop on vulnerabilities, special procedural needs, and the EU Pact on Migration and Asylum, organized by our OrderS member and PhD student Vasiliki Apatsidou. Thank you, Vasiliki, for getting us all together. The workshop will offer an opportunity to critically engage with the concept of vulnerability and special procedural and reception needs in the context of asylum, looking at the changes introduced by the new pacts on migration and asylum that will forever amend the architecture of the common European asylum system. Our speakers, representing key stakeholders from academia and practice, who the chair, Professor Elspeth Gild from the University of Liverpool, will be introducing shortly, will jointly analyse these changes, assessing their implications for vulnerable applicants, including LGBTI individuals, children, victims of trafficking, victims of torture, as well as refugees with disabilities. The discussion will centre on access to these special guarantees, these special procedures and reception conditions to which they are entitled legally, assessing potential shortcomings. And before passing the floor to our co-sponsor, UK Solidarity, for a few words, as well as the speakers, I would like to thank everyone for joining in person and online for an exciting discussion. My name is Violeta Moreno-Lax. I'm Professor of Law here at Queen Mary University of London and at the University of Barcelona. I am the founding director of the OrderS Centre, which is hosting us today. And I just wanted to say a few words on the centre, if I may. The centre focuses on the study of borders, as well as ordering and othering processes through law. It constitutes, or at least it aspires to constitute and offer an excellence hub for intellectual exchange and collaboration and the evaluation of the role of law in the making and unmaking of borders and their impact on global immobility. The idea is to connect scholars within and beyond Queen Mary to harness existing inter, multi, and transdisciplinary research into law, borders, and mobility, and thereby shape the future policy and research agendas in response to global challenges like the ones that the new pact is posing. So without further ado, I give the floor to our colleagues from UK Solidarity and thereafter to our chair, Professor Elspeth Gild, for a very exciting introduction of what is to come today. So the floor is yours. Thank you very much.
Good morning, everyone. Thank you so much to Vasiliki and to the OrderS Centre for hosting this important event and for inviting us to speak. My name is Tenley and I'm student president for Solidarity, a UK registered charity that has supported the hosting of this conference. Alexa, our CEO, is attending another conference today, but sends her apologies and best wishes for this important event. On behalf of us both and our wider team, I'd like to tell you a bit more about who we are and how our work connects to the theme of this important event. Solidarity is run entirely by volunteers who are students and young people, with more than 200 current volunteers across 25 different universities. We exist to drive forward lasting holistic solutions to support refugees and other people forced to cross borders in vulnerable situations. Specifically, we do this by bringing together a network of grassroots NGOs and supporting them to deliver legal assistance, which goes hand in hand with mental health support and trauma-informed approaches for refugees and asylum seekers in Greece. One of these partners is Defence for Children International Greece, and you'll hear from Nantina, their chief exec, shortly during this event. In addition to directly supporting refugee legal aid programs, our vision is also to unite the next generation of voters, educators, and policymakers in support of rights-based compassionate systems for migration and asylum. Through events ranging from quizzes and cake stalls through to conferences and poetry events, our student teams not only raise funds for grassroots refugee assistance, but also work to tackle harmful misinformation and anti-refugee rhetoric. We also do this through the sale of our organic vegan teas or solidarities, which are all designed by people with lived experience of displacement. They aim to spark conversations, acting as a visual show of solidarity with refugees at the same time raising vital aids. You can also buy them at the front today at the event, but also for those of you online, you can buy them through our online shop and you can also donate. We've also trained more than 40 NGO professionals in therapeutic approaches to legal assistance that incorporate mental and physical health considerations based on a capacity strengthening program that we have developed in-house alongside partners. This is particularly important in the context of people on the move with additional vulnerabilities or special procedural needs, as we'll be discussing today. Our partner organizations are some of the most impactful, innovative, and adaptive organizations you could ever hope to meet. And yet most of them are far too small to have been heard of, even by the general public in Greece, let alone in the UK. This has significant ramifications on their ability to access the funding that is so badly needed to sustain the work that they do in a time of increased legal, political, and media-fueled hostility. That's where we come in, to provide a shared platform and a vehicle through which the UK public, and in particular young people, can connect directly with grassroots refugee assistance. This is perhaps more important now than ever. As a border country to the EU, Greece receives a large proportion of the total number of people seeking safety. In 2024, more than one person every 10 minutes reached Greece, following deadly journeys across land and sea, often facing extensive border violence. At the same time, our partners are operating in a legal and political environment that is becoming increasingly constrained. The new EU Pact, which this conference discusses, serves to worsen many of these challenges. The asylum process is already brutal and not at all set up to uphold the rights of people with additional vulnerabilities. With no state-provided legal aid and completely ineffective vulnerability screening procedures, in Greece, people who have experienced some of the most extreme forms of persecution are already forced to reside in refugee camps with no access to basic services, and are then rushed through asylum procedures with no information being provided to them whatsoever. The consequences, namely unjust rejections and a loss of access to healthcare, cash assistance, and the right to safe housing or education, can be deadly. Within the new EU Pact, opportunities to criminalise people seeking safety deny them due process during so-called crisis protocols and rush decisions in a way that penalises the people who most meet the criteria for refugee status are numerous. One of our partners recently worked with a client named Abdul, a queer man who had experienced severe persecution as a result of his sexuality, causing lasting damage. Abdul initially received a rejection. His story was deemed not credible by the asylum authorities on the basis that he explained his story too clearly and with too little emotion. Colleagues at our partner organization recognized that Abdul was neurodivergent, and his way of expressing his emotions in a logical way is very common among people with autism. They arranged for him to have an attestation from a psychologist and provided a legal submission highlighting the injustice of this subjective credibility assessment. As a result, Abdul has now received international protection. This was only possible through the intense efforts of non-governmental actors and highlights the injustice and often the arbitrary nature of decision-making regarding people's lives. Under the new pact, Abdul would have even less chance of being able to access his fundamental rights to safety. The pact is likely to lead to increased instances of detention at the borders, screening processes that give no regard to the effects of trauma or persecution on a person's ability to articulate their experience, and a focus on speeding up the process instead of fully understanding the reasons why each person has sought safety. For this reason, we need to act now. In addition to raising awareness of the most harmful elements of the pact, we need to work together and leverage the expertise of individuals and organizations who are closest to the communities that are likely to be most marginalized by these changes, namely children, people with diverse sexual and gender identities, and survivors of trafficking and torture. In particular, those who are experiencing severe post-traumatic effects. This event is an important step in exploring the challenges and opportunities to work together to defend and uphold the rights of people caught up in a system of scapegoating and externalization. We are sure that there will be some important discussions today and really look forward to being part of the conversation to reimagine what truly rights-based support could look like for traditionally marginalized groups. Thank you again, and we hope you enjoy the event.
Well, I must have Gail that Juliette has already introduced me. I want to thank our first speaker, Tiffany Fuentes-Lema, for really moving statement about what your NGO does and the needs out there for further work. I think that anybody who's worked in the field in asylum will be very cognizant of how important it is for people to really get engaged and to help individuals. So we'll all buy your t-shirts at the end. I think that you gave us a really good outline of what we're trying to do at this seminar now. So I don't think I'll need to repeat any of the objectives, which I think are clearly stated in respect to vulnerabilities, procedures, and the EU Pact. And I think we can start immediately with Vasiliki Abatsitu. She is a PhD candidate here at Queen Mary, and she's also a tutor at the University of London. And her research focuses on EU asylum law, specifically the impact of border procedures on human rights. And I think for any of us who are looking at the Pact, anybody who's had an advanced opportunity to read some of the work you've published on what border procedures are, what the Pact means, this has been a great relief. You make what Steve Pierce describes actually comprehensible. This is a wonderful addition to our work. I'll hand over to you. Take us through the.
So good afternoon, everyone, and thank you very much for being here today. Also, thanks to Violeta for helping me organize this event and making it a reality, and Elspeth for joining us today for this event. And of course, our speakers who have traveled from Greece, Sweden, and from London to be here today for this event. Thank you very much. So today I will be discussing the EU Pact on Migration and Asylum and how it may impact access to special procedural guarantees. I will provide first a very short introduction on what special procedural guarantees may entail, and then I will explain how the EU Pact on Migration and Asylum may impact access to these guarantees. And finally, I will try to provide some recommendations for the future. So vulnerabilities are not explicitly defined in the common European asylum system. Rather, what we see in this framework is that there is a connection, there is a linkage between identifying vulnerabilities and providing access to special procedural guarantees. So those who are identified as requiring special procedural guarantees should receive adequate support to ensure that they have a proper access to effective asylum procedures. The additional guarantees may entail, for example, additional breaks during the interview, the possibility for the applicants to move if necessary for their health, the flexibility in assessing inaccuracies or contradictions, and other elements such as to give enough time to the applicants to prepare for their asylum interview, to collect the necessary evidence and documentation, especially if they are vulnerable and they need to contact other medical and psychosocial actors. So when a vulnerability is detected, it obliges the authorities in all procedures to recognize and adjust the procedure to the corresponding needs of the person. The EU Pact on Migration and Asylum introduces several challenges to the asylum procedure, and this is something that may impact in practice access to special procedural guarantees. I'm not going into detail explaining what exactly the EU Pact entails, because this would require a separate presentation, but I will mostly refer to the new screening regulation and the asylum procedure regulation, which are two texts which explicitly refer to special procedural guarantees. Just to mention that the EU Pact on Migration and Asylum was proposed back in September 2020 because the previous reform of the Common European Asylum System had not been concluded. And after years and many years of negotiations, finally there was an agreement between the Council and the European Parliament in December 2023. We have the texts all formally adopted and published in the Official Journal of the European Union in May 2024, and we expect the pact to become operational in the summer of 2026. So all member states and the authorities have 1.5 years to prepare their asylum and reception systems for the implementation of the pact. So as I said, I will refer mostly to the screening regulation and the new APR, the Asylum Procedure Regulation. And I will start with the APR actually, because it is the text, the Asylum Procedure Regulation, which acknowledges that some applicants may require special procedural guarantees due to factors such as their age, their gender, their sexual orientation, gender identity, disability, serious physical or mental illness, or past experiences of torture, rape, or other forms of psychological, physical, sexual, or gender-based violence. This is acknowledged in the Asylum Procedure Regulation. But in order to ensure that these people will have access to special procedural guarantees, we need to make sure that there is an identification mechanism. So how these applicants will be identified as vulnerable and as applicants that require special procedural guarantees. We now have a new screening regulation, which was introduced as part of the EU Pact on Migration and Asylum, which establishes for the first time and introduces a new screening procedure. It is quite positive that this regulation does not only include the registration, fingerprinting, nationality verification, and security checks, but at least it mandates a preliminary health and vulnerability check, which is quite positive. However, some issues may arise in this stage, in the screening stage, because first of all, the screening procedure lasts only 7 days. So you understand that in this time frame, all the procedures should take place, and there are not strong safeguards for identifying vulnerabilities. There is a reference to conducting a preliminary health and vulnerability check, but not additional safeguards. And this means that the less visible vulnerabilities, such as applicants who experience trauma or other forms of psychological violence, survivors of trafficking or survivors of torture who need time to contact medical actors and other actors that offer psychosocial assistance, it's difficult to identify these vulnerabilities in just 7 days. Other more visible vulnerabilities, let's say, like applicants who have serious health issues or pregnant women, okay, it's quite straightforward, but it's problematic that in just 7 days, this assessment should take place and there is not any possibility for extension, which means that sometimes the screening may be considered concluded, even if the applicants have not gone through vulnerability assessments, which is also the case today very often. So why all this is problematic? Because depending on the information that will be collected during the screening procedure, the people will be referred to the appropriate procedure, which may be either the regular asylum procedure, which is a procedure which entails the full safeguards of the legislation, or to a border procedure, which, as we will explain in this presentation, is a quite substandard procedure. So depending on this minimum information that will be collected on the screening, the person will be directed to the proper procedure, let's say. This means that sometimes vulnerable applicants that have not been detected as such will be directed and referred to the border procedure, even sometimes, as I said, without the vulnerability assessment has taken place. So this is the first aspect that may be problematic. And of course, the result of the screening cannot be appealed because it's a screening form. It's not a formal administrative decision. So you understand that the result is quite binding and can only be assessed then in the asylum procedure. And the second aspect which is problematic is that even in the cases that the applicant will be considered vulnerable through the screening procedure, for example, or another vulnerability assessment, this applicant may still be referred to a border procedure. And why is this happening? Because the Asylum Procedure Regulation, the Asylum Procedure Regulation says that vulnerable applicants will be exempted from border procedures only if the adequate support or the necessary support cannot be provided in these procedures. So you understand that the new regulation requires actually a double assessment. First, there should be an assessment whether a person is vulnerable and requires special procedural guarantees. And then there should be a second assessment where the authorities will assess whether the adequate support, the necessary support, can be provided for the specific applicant in the context of a border procedure. And of course, it's problematic that the regulation does not further define what necessary support actually means, and it does not explain how adequate support can be provided in the context of border procedure. So in practice, it's very common for the authorities to not exempt applicants from border procedures because they say that the special procedural guarantees exist in both the regular and the border procedure, and that the safeguards sometimes are the same. So it's not very common to see exemptions from border procedures because the necessary support cannot be provided in these procedures. But is this true? So, I mean, is it true that in border procedures there are enough safeguards? So yes, the last 4 years I'm researching border procedures because it's the topic of my PhD thesis, and I have conducted interviews with many actors that work in the field, in the academia, in the policy level, and they all agree on something, that in border procedures, the focus is on speed. So everything in border procedures should happen very fast. Sometimes the focus is so much on the speed that we forget that the asylum procedures is a procedure to assess and to examine whether someone escapes from persecution. And we focus only on speed. These are very fast procedures, which means that, first of all, applicants who arrive in a foreign country and have experienced trauma, who are survivors of trafficking, who have suffered from other forms of physical or psychological violence, they are referred to the interview very fast. Sometimes the interview is scheduled, for example, in border islands in Greece in just 1 day or 2 days. So they don't even have the time to prepare for the asylum interview, to collect the necessary evidence. And border procedures also prevents them from having access to legal assistance because sometimes they don't even have the time to contact a lawyer because the focus is on the speed. But even if they manage to find a lawyer and access legal assistance, again, it's so rapid, the pace in these procedures, that the lawyers may not have the time to prepare them adequately or contact medical actors. I remember a testimony for a lawyer that I interviewed for my PhD thesis that mentioned that we contacted the medical actor in order to issue a certificate that the applicant was a victim of torture. And in the meanwhile, the asylum interview had already been scheduled and the decision had been issued. So while they were awaiting for the medical certificate, the interview had already been conducted. So yes, the focus is so much on the speed that even it puts pressure to the authorities, to the case workers. You will see that in border procedures, the interviews may last just half an hour or an hour. The case workers will not inquire about special procedural guarantees and vulnerabilities. If there's not a lawyer in the interview, sometimes they may not even ask questions about vulnerabilities. Even if a lawyer is there, maybe the situation is better. But even if the case workers realize during the interview that the person may be vulnerable and has not been detected as such in a previous stage, they will never interrupt the interview to refer them for a vulnerability assessment. And the reason is that in border procedures, the focus is on the speed. It's not on truly identifying the needs of the person. So I have to add on in this that with the new asylum procedure regulation and the screening regulation, the non-entry legal fiction is also legitimized, which means that applicants in these procedures will be considered as not having entered into the territory. So it's kind of difficult to assess that and to say that the adequate support can be provided to applicants with special procedural needs when they are referred in so fast-track procedures where the non-entry fiction applies, which simultaneously means that they may be kept to detention or de facto detention for long periods of time. Another concern is that the new crisis regulation, which was also proposed as part of the pact and is now agreed, which addresses cases of mass arrivals, or it says it addresses cases of mass arrivals, says that the border procedure may be applied to the majority of asylum seekers in case there are mass arrivals, and in cases that they are characterized as instrumentalization, which is a new concept we see in this regulation, border procedures may apply to all applicants, which means that there will not be simply exceptions from border procedures. And this is dangerous because this means that in case of mass arrivals, states may implement massively border procedures and implement the non-entry fiction to all asylum seekers, including applicants with special procedural or reception needs. So this was a very brief explanation of what the new pact entails regarding access to special procedural guarantees. But as I said in the beginning, member states have 1.5 years in order to implement this legislation. And I believe that there are provisions in the legislation that can be used in order to ensure that the pact is implemented in a way which respects human rights and takes into account the special needs of vulnerable applicants. So to ensure that the vulnerable asylum seekers receive adequate protection, first of all, it is important to strengthen early vulnerability assessments. So the screening procedure should not be considered as concluded when a health and vulnerability check has not taken place. Even if, 7 days are not enough and the proper vulnerability assessment has not been conducted, no referral to any procedure should take place. Article 20 of the Asylum Procedure Regulation allows for a 30-day period for the assessment of vulnerabilities. So states have even a month after the 7 days of the screening to conduct the vulnerability assessment. But in the meanwhile, the person should not be referred, for example, to the border procedure without the proper vulnerability assessment. And have in mind that it's not only a proper vulnerability assessment is not just a medical check, because as we said, through a medical check, maybe visible vulnerabilities can be detected, but it needs a thorough psychosocial assessment. So this should be done as early as possible, if not in the 7 days of the screening, in the 30 days that are prescribed in the screening in the Asylum Procedure Regulation, and the referral to a procedure and an interview should be scheduled only after this assessment has been concluded. So this is very important because what we see very often in practice in the field is that many times the interview is scheduled before a vulnerability assessment. This is very common, especially in the context of border procedure, where the emphasis is on speed. And finally, but also very important, that when an applicant is considered as vulnerable and as a person that has special procedural needs, this person should automatically be exempted from border procedures. So there should be a presumption that adequate support cannot be provided in the context of border procedures, which, as we explained, are substandard procedures. They're substandard procedures even for the applicants who are not considered to have special procedural guarantees needs. Imagine how much they are not working also for applicants who have been assessed as vulnerable and thus having special procedural guarantees. So to conclude, the lack of a clear definition of adequate support in the legislation in the Asylum Procedure Regulation, the increased reliance on fast-track border procedures where the non-entry fiction is applicable, and the challenges in early identifying vulnerabilities create significant risks for those most in need. To ensure that special procedural guarantees are truly effective, reforms and policy recommendations now must strengthen vulnerability assessment, safeguard procedural rights, and ensure exceptions from substandard procedures. Always, it is important to ensure that these applicants will be referred to regular asylum procedures where the full set of rights and safeguards is applicable. Thank you very much for your time, and I'm looking forward to the discussion that will follow.
I think that you gave us a terrific outline of the importance of assessment and the emphasis which is going to need to be placed by all of the actors who are dealing with asylum on the adequacy that therein lies key. It's almost depressing to think that we all acknowledge that border procedures are substandard procedures, and yet we're now seeking to cut out at least the most vulnerable, so that the slightly more robust will go through border procedures. It's all a bit worrying. Our second speaker is going to be Ninos Varadakis, who I think everybody knows. He's a legal officer at the Refugee Support Aegean, a regional public organization focusing on strategic litigation in support of refugees, monitoring human rights violations, as well as the provision of legal, social, and humanitarian support in individual cases. And you're going to look at systematic non-compliance with duty to procedural safeguards and special situations. Do you want to come here to next? And you have 15 minutes.
Thank you very much, Elspeth. I'm the second Greek of the day, and we have more. So apologies in advance for this. Many thanks to the Border Center for organizing today's discussion and for having me. It's really a pleasure to be with all of you today, in person and virtually. Vasiliki really painted a perfect, albeit slightly depressing picture of what's to come with the new Pact on Migration and Asylum when it comes to standards on processing claims for protection, claims for asylum in a border context with what are indeed substandard procedures, extremely truncated, focused, if not obsessed with speed and rapid delivery of decisions. What I thought might be useful to contribute with in our discussion today is the practical implications of this in a border context such as the Greek one. And part of the reason for this is that Greece not only prides itself, unfortunately, on being the main source of inspiration of this new set of EU rules that we will be grappling with for the next years, if not decades, but it's also the EU country that has, let's say, the busiest border procedure. Last year alone, we had just under 35,000 people whose claims were processed in the context of such a procedure. The reason for this is that Greece applies border procedures to all arrivals on 5 of its main islands in the Eastern Aegean close to Turkey. These are islands such as Lesbos, Samos, that have become famous, if not infamous, for substandard horde conditions for refugees and asylum seekers. So even though the letter and spirit of EU law, already since the advent of border procedures, envision these processes as a very particular category that would be reserved to a filtering tool. The notion was that we would use these very speedy procedures to filter out claims that would be manifestly unfounded or inadmissible, so as to ensure that the regular procedure in an asylum system has enough time and resources to process everything else. Greece has flouted that standard forever. So since we've had border procedures in practice in 2016, the idea that is put forward by the Greek authorities and implemented to date is that every claim of a person arriving on the islands is to be processed in a border procedure, no matter how complicated, no matter how well-founded or unfounded. So that means that the general population of asylum seekers suffers the consequences of these substandard processes. Now, let's couple this with some of the aspects that Vasiliki also covered in her presentation. What are the implications of the new pact? Speedier procedures, especially when it comes to screening, so the initial stage of identifying a person and also tracking whether they have special needs, whether they qualify as a vulnerable person. That is to be conducted within a time frame of 7 days, which is mandatory, which means in all likelihood, we will deem this process to be completed after 7 days, no matter how rudimentary, how faulty this has been. Border procedures, of course, become broader. We have a multi-dimensional expansion, both in terms of scope, but also in terms of discretion afforded to member states for the sake of administrative convenience, and the non-entry fiction, which would basically mean containment, de facto deprivation of liberty. This, I think, is crucial for us to bear in mind, that when we have processing of cases of people that are essentially detained, inaccessible to services, inaccessible to the enjoyment of basic rights, this has inevitable and unspeakable consequences on their ability to really put forward a claim and explain why they're seeking international protection. In addition to this, we have a very strong expansion of procedural pitfalls, little tools and reasons in the architecture of EU law for denying an asylum claim, not because the person is not a refugee, but because the person came from a third country that is a safe third country for them, or the person implicitly withdrew their claim, or the person did not appeal their decision in time. All of this becomes much easier for states to apply, ergo much more difficult for people to navigate in their search for protection. Now, against this backdrop, if we sort of zoom back in on the Greek islands and what's happening in practice. The Greek border procedure, as we said, last year covered about 35,000 people. The overwhelming majority, over 90% of these claims, were actually accepted in practice. This has to do mainly with the characteristics, the countries of origin that people arriving in Greece flee from, mainly Afghanistan, Syria, but also Palestine, Yemen, Eritrea, and others. The picture could be very different in a country like Poland or Finland or Italy. So no matter what type of composition of arrivals or flows, as politicians would love to say, a country might be dealing with, to have a system that is well-functioning, fair, and properly taking into consideration core legal standards is absolutely paramount, because this could change in Greece tomorrow, for instance. So even though we have a very strong rate of protection of positive decisions for people that navigate asylum procedures at the border in Greece, we do confirm from our practical observations as a civil society actor and also as a main litigator that the standards are consistently not complied with, and that core safeguards are not respected and implemented in Greece. Let's look at this across the different stages of the process. If we speak of screening, of the identification phase, we have a recipe combining a truncated process with deadlines that have to be complied with chronic gaps in staffing of not only medical units, but also registration officers in the different islands. This means, in essence, that it is extremely likely, if not the rule on certain islands, that people will be screened without ever being seen by a doctor, a psychologist, or a social worker. This remains the reality on islands such as Kos, that to this date host on average about 2,000, 3,000 people in a camp on any given day and have no single doctor. What this actually gives is not only, of course, denial of basic care for the people that need it, and you can imagine that people may have all sorts of extremely serious and pressing medical conditions that need to be attended to, but also that the start of the asylum process is already extremely tenuous. We're opening basically a case file and about to examine the claim of a person without really understanding key facets of that person's story. So when the person is then called to be interviewed by an asylum service official, there's a very strong part of the information that is missing, and perhaps, as we'll hear later, a strong likelihood that the story will not be deemed credible. The story will not be believed because it cannot be corroborated against other evidence. Of course, speediness and haste follows people throughout the different stages of the process. People get interviewed, as we heard already, extremely quickly before the case file has been ready. For the sake of administrative convenience, Greece is a member state that does two interesting things. And by interesting, we mean kind of illegal. Firstly, the rule is not necessarily that the person will be interviewed by their decision maker, by the asylum service caseworker who will actually decide on the fate of their claim. We consistently resort to a very convenient approach for the administration, which is to enlist a different interviewer, usually from a body that is not the asylum service, not the national authority that is in charge of processing the claims, but to officials of the EU Asylum Agency. This is the office that was formerly known as EASO, European Asylum Support Office, whose role, among other things, is to provide human resources support to different member states if they ask for it. So it would be extremely regular on a Greek island for a person to be interviewed by an EU Asylum Agency caseworker who will prepare a transcript, and then a different person who's never met the asylum seeker, who's never heard, seen them, to take a transcript and make a decision based on what is written in there. Second point, which is often interrelated, is the use of remote interviewing. This became, I think, a very fashionable option for many member states after the COVID pandemic, and it's something that Greece has massively invested in. The rule, per official admission of the head of our asylum service, is video conferencing rather than in-person interview, which means that people very rarely will actually meet a human being in person when they're called to share the most intimate parts of their personal story of flight and search for protection. And actually, both of these things are elements that we very often put forward as legal representatives of asylum seekers to really highlight the need for special procedural guarantees for persons that have experienced torture, other forms of trauma, trafficking, you name it. We at least request the basics for the person to be seen by their decision maker in person in order for all elements that are relevant to the claim to be taken into consideration. Unfortunately, these requests are never heeded. So the standard approach of the asylum service is to not accept to afford special procedural guarantees adequate support, as Vasiliki also mentioned, even when explicitly requested by the person, and to nevertheless go through with the interview and conclude the interview as soon as possible. So inevitably, any discussion on vulnerability at the practical level, and definitely in the border context, becomes a discussion on litigating and adjudicating procedural irregularities. How can we remedy, how can we make up for lost space when the basic rules of refugee status determination are not respected in practice? At the level of the administration, the asylum service, we are usually met with a refusal, even where, as we said, the requests are explicit. We want an in-person interview. We want the person to access rehabilitation services in order to overcome the effects of torture or other forms of trauma before being interviewed. Also does not happen because the resources and the infrastructure is not there. And also, quite likely, the political will to make this happen is not necessarily there either. What happens when all of this gets appealed? What happens when the negative decision is issued and then we contest this before the appeal body? Greece has a sort of hybrid system of entrusting the asylum appeal stage to an administrative authority that is exclusively staffed by judges. Don't ask me why this is, and don't ask me how that works. They don't call themselves a court, but they consider themselves to be judges. At this stage, our experience, and I think that is the experience of practitioners more widely in Greece, is as follows. Those procedural irregularities we've been discussing are raised and put forward as key grounds for appealing a negative decision. So in some, we explain the process is not right, it needs to be conducted again because the person was not properly heard and their claim was not properly examined. And we have a generalized refusal on the part of Greek judges, on the part of the appeal body, to consider this point thoroughly. This can take the form of different types of reasons provided for not re-examining those claims as the authorities should. One standard ground that we hear throughout case law over the past couple of years is the so-called irrelevance of vulnerability to refugee status determination. The position is expressed that whether the person was considered vulnerable or not would impact only on their living conditions, only on their reception, and it has nothing to do with whether they qualify or not for international protection. This is, to me, contrary to EU law quite clearly, and judicial review at the higher level also agrees with this, and many decisions get quashed several years later, but it still remains a key reason for denying vulnerability-related considerations on appeal. A second often related and often combined point is the no procedural harm argument. So Greek judges take the view that even if the person was unfairly denied the special procedural guarantees that come with recognition as a vulnerable person, there was no harm done. The person managed to file an appeal, they managed to contest the decision, so they are now in the appeal procedure, which means they still have access to a thorough examination of their claim. So even if the appeal body will not interview them again, because we rarely have oral hearings at second instance, there's no harm done. They cannot demonstrate that this had an actual causal link to them being harmed. The final point, which is my personal favorite, but it's a bit of a more restricted one, is that the appeal body is not competent to decide on vulnerability matters. This is a screening question. The person should have been properly screened. So this is not our business. And that's the end of the story. Now, when all of this gets judicially reviewed before actual courts, and again, in a very Greek way, we can discuss in the Q&A because it's sort of slightly boring. Very often it's the same people that adjudicate asylum appeals. That's another sort of tradition that we have. Very often these decisions get annulled because these procedural errors matter, and of course they have to matter. But for the individual concerned and her search for protection and her claims proper consideration, the damage is, of course, already done. We speak of a systematic practice that has been there since the start of the Greek border procedure, despite often clear provisions in EU law that get them transposed into domestic standards. The system that processes asylum claims does not show any interest or any preparedness to be attentive to these points. And our search for now towards mobilization, activation on the part of actors that would be in charge of enforcing EU law at the general level, EU institutions like the European Commission, unfortunately has delivered very limited results. The European Commission, which is responsible for enforcing standards across the entire EU, is very well aware of the issues at hand, and yet it has made no use of the enforcement tools it has at its disposals to make sure that Greece, as any other member state, complies with the law. This, more or less by way of sort of introduction, very thankful to all of you again and looking forward to the discussion. Thanks.
Us for a really good explanation of how this new pact procedure on screening of APR is actually going to work in light of the experience where it comes from. And I think it's a pretty frightening picture which you draw as regards people with vulnerabilities, of which many just a question for our audience here. We had rather thought we'd give you a 10-minute break to get a cup of coffee, but maybe you want us just to continue on, in which case I could perhaps suggest, if you want a cup of coffee, help yourself to one and keep going. Would you like to continue, or would you like a bit of a break? We've only really done half an hour's worth of work so far, so it's a bit early to do a break.
You want
Keep going, and help yourself
because we need to connect the presentation now.
Yes. Okay, so I'll just introduce our speakers, who is Sophia Sisaku. Sophia, you're a PhD candidate in law and sociology at the University of Lund in Sweden, and an asylum lawyer in Greece herself. And you're going to focus more on the credibility assessment, particularly in the LGBTQ context. And as you know, it always takes half an hour to think up a PowerPoint. Get yourself a coffee and just if you want we go. I think I might have sandwiches. Somebody should tell me.
It's for after the event. But if you want some coffee.
Thank you.
Wow, because we're so much down cases for kids sometimes how the system is. They can hear us very good, just that when you speak.
Yeah, I mean now during the break. And we've lost our singers.
Okay, I will do it like that. I don't know if this is sharing. And being shared online. So people from online room cannot see it. So I think this is now, can we save it? So I put it here. This maybe.
The PowerPoint.
But it doesn't show.
I think we can do it from Zoom.
Search.
But the problem is that we need to turn the slides in both, I think.
No.
Only here.
Here.
Ah, okay.
Yeah.
Okay, so this one.
Then search here.
Okay, now it's
And
screen.
then
Now it's
third
search.
second. So you do big. Maybe the big here. And
Now you
now,
turn with this.
now it should be
It's a great pleasure, Sophia, that you're here and that you were able to come. And I'll let you go ahead with your credibility presentation.
Yes, thank you very much for the introduction and many thanks to Vasiliki for organizing this event. My name is Sofia Zisakou. I am a PhD candidate in the Department of Sociology of Law at Lund University. And before my PhD, I was working as an asylum lawyer in Greece. So it was through my experience as a legal practitioner that I decided to focus more in depth on queer asylum law. My PhD thesis is more of a feminist and queer critique to the process of credibility assessment. And I focus in particular on the role of emotions in the process. However, for the purposes of today's presentation, I will focus more on the legal aspects of the issue. I can't change the slide for a reason. So my aim today is to discuss general challenges in the credibility assessment process at EU level, to present, evaluate and critique the relevant framework, and to reflect on alternative epistemological and methodological approaches. So I should say that this is not a general presentation on challenges that queer asylum seekers face under the new EU Pact. And this is because, as mentioned before, the main challenge that asylum seekers face under this new framework is basically the restriction of examining asylum applications on the merits, exactly due to the extensive application of safe country concepts and the increased use of borders procedures, accelerated procedures, and inadmissibility procedures. So this presentation will focus on these asylum applications examined on the merits. A brief note on the term queer. I use the term queer as an inclusive term, drawing on queer theory and queer of color critique as an epistemology that challenges rigid and exhaustive definition, taxonomies, and identities. And regarding the methodology of this research, I conducted a desk study analyzing Court of Justice of the European Union case law, UNHCR guidelines on sexual orientation and gender identity asylum claims, and European Union's Agency for Asylum material. Regarding the case law of the European Court of Human Rights, I should briefly say that the court insists on its position that it's national authorities that are responsible for the evaluation of a claim's credibility, and that's why the court's case law is not very helpful on the issue. Simultaneously, I draw on 27 semi-structured interviews that I conducted with decision makers in Greece for the needs of my PhD between 2021 and 2023. So following the abolishment of the discretion clause was the idea that applicants could be returned to their countries of origin, and by hiding their sexual orientation, they could be protected. So following the abolishment of the discretion requirement by the Court of Justice of the European Union in the XYZ judgment in 2013, credibility became, we could say, the major challenge and the main reason for rejection in queer asylum claims. In the ABC judgment, the Court of Justice of the European Union elaborated specifically on the topic in what we could describe as a benchmark decision and a paradigm shift on the topic. So in this judgment, the court rejected the argument that self-identification is an adequate element for substantiating applicants' credibility, and defined that self-identification should be only the starting point of the process. This is more or less UNHCR's position, which we could say that puts self-identification in a bit higher level mentioning in their guidelines that self-identification is an indication of applicants' credibility. So in the ABC judgment, the court examined certain previously extensively applied by member states practices and defined them as forbidden due to their incompatibility with human rights standards. These were questions that had to do with sexual practices of the applicant, the use of medical and psychological exams, and use of evidence such as photos and videos, often with sexual content. It would be worth mentioning that this prohibition is also included in the preamble of the new qualification regulation. At the same time, the court examined two other practices, the use of stereotypes, let's say the expectation from the applicant to be aware of LGBTQI+ organizations or queer meeting points, and is everything okay?
Yeah, I'm just trying to take away the ping that you're going to be hearing every time that you get an email, but I cannot do it from here, so sorry.
No worries. Yes, and the second practice was the rejection of an asylum application due to late disclosure. So these two practices, according to the court, should not consist the only reason for rejecting an asylum application, and this is not due to their incompatibility with human rights standards, but because they would violate the obligation for an individualized assessment according to the common European asylum system. We should say that what has to do with late disclosure is also included in the new qualification regulation. Although the court defined what should not be applied in the assessment, it should not proceed to give guidelines and elaborate more on what should be applied in the process, and this was not clarified further in the F judgment that followed in 2018. So in the meantime, the DSSH model from difference, shame, stigma, and harm was suggested as an alternative credibility assessment model, which could move the focus of the examination from applicants' sexual practices to their inner emotional journey, exactly by exploring their feelings of difference, stigma, shame, and harm. So this model approaches SOGS, sexual orientation, gender identity expression, and sex characteristics, not as a matter of sexual practices, but rather as a matter of feelings and identity. This SH model was initially endorsed both by UNHCR and European Union's Agency for Asylum. So we read in UNHCR guidelines that exploring elements around the applicant's personal perceptions, feelings, and experiences of difference, stigma, and shame would help the decision maker ascertain the applicant's SOGI rather than a focus on sexual practices. However, as we'll see and explain further today, this model contributed to the development of, let's say, a second generation of stereotypes that, according to the Court of Justice of the European Union, should not be applied in the assessment. Moving on what's going on in practice, what we see is a very high focus on applicants' feelings. So as Panos, one of my research participants, mentioned, in another case, when I asked an applicant from Gambia what he enjoys in his relationships with men, he replied that what he likes is to have anal sex with men. I was very confused and I asked my team leader how I could assess that claim. What she answered me was that sexual contacts have nothing to do with homosexuality. Sexual orientation is about feelings and love. In addition, applicants are expected to describe feelings of oppression, suffering, and shame in their purportedly backward countries of origin. So as Lila said, it is expected from the applicants to have negative feelings and a negative opinion about their countries of origin. In any case, this is the reason why they fled their countries and came to Europe, where they could find safety, regardless if they have been persecuted or not. Applicants are also expected to have passed through a hard and challenging self-realization process, which is supposed to be accompanied by negative feelings. As Vicky simply put it, what I expect to hear from the applicant is the pure difficulty. What does it mean to be gay in Iran? On the other hand, applicants are expected to feel happy, out, and proud in Greece and to be in a monogamous and homonormative relationship. According to Manos, applicants' life in Greece is also a field of examination. Since in Greece they are free, it is an indication of credibility if the applicant has come in touch with LGBTQI organizations or if they are in a relationship here. However, not only authorities' expectations are focused on applicants' emotions, but also, and in lack of an effective method of assessment, caseworkers tend to base their decisions on what they describe as instinct, as intuition, and as atmosphere of the interview. So as Natalia put it, when you assess emotions, you can't help but bring your own emotion into it. So basically what we see here is that applicants are expected to provide an account on a linear affective trajectory from oppression, suffering, and shame in their purportedly backward countries of origin to liberation, happiness, and pride in Europe, reproducing, we could say, a dichotomy between the progressive West and the backward pre-modern East. And this is an essentialist and monolithic representation that erases complexity and nuances from applicants' lived experiences. As Athena, in a critical account mentioned, emotion is something that continuously evolves even during the interview. It can change at any moment. In the asylum system, feelings are approached as solid entities. Everything must be very well structured. However, neither sexuality nor emotions remain unchanged. Taking into account some of this critique, UNHCR, in their summary conclusions of 2021's Global Roundtable on the issue, highlighted that their guidelines should be revised, that authorities should avoid adopting any model for credibility assessment, and that credibility assessment should be conducted on the basis of an individual, balanced, intersectional, and holistic evaluation, placing due value on the claimant's self-identification without expectations of emotional journeys and respecting the principle of the benefit of the doubt. However, in the Believe It or Not conference that we organized in September 2024 on the topic in Amsterdam, UNHCR representative mentioned that the revision of guidelines is a quite complicated process and it's not among UNHCR's current plans. Regarding EUAA, we should say that in their general guide on credibility assessment and evidence, this SH model is included. However, it is mentioned that the model has been misused, and this is due to a tick box approach. However, in their 2024 practical guide, this guide was issued in November, last November, and it's the first time that the agency issues a guide specifically on the topic of SOGS asylum claims. The model is not included at all. A few words about this guide. This guide addresses many of the current problems, taking into account the growing scholarship and critique on the issue. However, as the ABC judgment, although of course court judgment is legally binding while a guide is just a recommendation and it's soft law, this guide focuses more on what should not be done and not that much on what authorities should do. Among improvements, we should say that the guide mentions that SOGS can be fluid and evolve, that self-realization could be associated with positive feelings, and that absence of an internal struggle or not identifying one moment of self-realization are not indicative of lack of credibility. It is also suggested to caseworkers that they should adopt a flexible approach during the interview. However, fields of examination in this guide remain the same. So applicants' credibility is still associated through their awareness of SOGIESC. Romantic and sexual relationship are suggested as fields of examination, disclosure of their SOGIESC, and their familiarity with LGBTQI+ support groups. So basically, applicants' credibility continues to be measured in a way through a neoliberalized idea of how the future good sexual citizen should look, behave, and feel. To conclude, what I try to explain here is a circle of problematic practices. So basically what we see is that problematic practices are being replaced by problematic practices. And that's why credibility assessment in queer asylum claims in legal scholarship has been described as an impossible task. However, I would like to draw on queerness and affect as epistemologies of openness that exactly trouble and disrupt exhaustive definitions and rigid identities. So we could imagine of queerness and emotions not as an identity or a property, something that someone strictly is or something that someone has, but rather as a relationality, as a potentiality, and as a space where unpredictable stories, unpredictable queer stories could be told and performed. As Andonis shared with me, sometimes applicants' answers are surprising. When I asked a lesbian woman from Senegal about her self-realization and feelings, she answered me, "How should I feel? I was feeling perfect and I was doing what I wanted to do. A lot of sex. If she was afraid, of course she was afraid, but this doesn't mean that she couldn't enjoy her sexuality." So, although I'm aware that ambiguity and uncertainty is exactly what disturbs legal norms, which always look for security and stability, we should say that there is no magic solution to the problem, but rather, as Donna Haraway would argue, we should stay with the trouble, having, of course, in mind that there are legal principles that authorities could use when assess these claims, such as the benefit of the doubt that is highlighted by UNHCR. Thank you very much, and I would love to continue discussing on this if you have any questions.
Thank you very much, Sophia. That was a really enlightening presentation about the credibility question. I think that now having read the cases that you're referring to, the way in which you look at them and present them actually is providing me with a number of new insights into what is a very complex area of decision making. And our next and our final speaker is, our second speaker in this second part for today is Nicola Bustin, who is a lecturer of law within the School of Gender Law and Media at SOAS, where Nicola, you lecture on and research on the rights of refugees and migrants under international and EU law with a focus on persons with disabilities, and I think you're going to be taking us there now. You have 15 minutes.
Thank you very much, Elspeth. Good afternoon, everyone. It's a real pleasure to be back at Queen Mary. Thank you to Baziliki for bringing us here today, the OrderS Center for hosting us, and to all of you, whether you've made the trek to join us or you've taken time out of your day online. Yes, I am going to be reflecting on the rights of disabled applicants, disabled asylum seekers, disabled refugees, and I want to reflect in the next 15 minutes on those elements of the pact insofar as they raise questions in possible interaction with international human rights law, for example, so that they can provide a more protective interpretation of the pact itself. I won't be repeating what my fellow panelists have already outlined in such wonderful detail, except to remind you that when we are speaking of disability, the main vehicle through which this exists in the pact is through the form of vulnerability. So disabled persons, whether as disabled individuals for the purposes of procedures, for the purpose of receptions, are classified and categorized as vulnerable. And the attempt to define vulnerability is erratic, and it is certainly a patchwork attempt. But what is clear, and as we have heard, is that identification as vulnerable does entail duties and provisions of support. So clearly we have a pact, however, that in multiple ways, whether through the proliferation of border procedures, whether through the attempts to contain, the emphasis on instrumentalization, causes harm and will cause harm. I think everything we've said today gives us that. And so the emphasis on vulnerability within the pact exists as a remedy to the harm that is envisaged as the new norm. So even when we're speaking about the multiple ways in which vulnerability is mentioned a lot more than in previous instruments, and even disability is mentioned much more than in previous instruments, I think it's important to keep that in mind. At the same time, I would also say that in an understanding of vulnerability that generates duties, that generates obligations to support, that locates the vulnerability outside of the individual is one to be welcomed. It's one that affirms vulnerability as being contextual rather than inherent to the individual. But then, of course, the difficulty lies in what Vasiliki outlined earlier, which is if the remedy, if the duty is to provide adequate support, at which point do we determine what that adequate is and how? At which point do we say that the disabled refugee has actually had their contextual vulnerability met? And so to that end, I want to take this time to reflect on 3 points that I believe can make a difference to the implementation of the Pact for Disabled Refugees and provide some kind of palliative or some kind of improvement, one would hope, to its implementation and operationalization. The first of these would be what I think of as the invisibility of disability-specific protections in the Pact itself. So there is a complete absence of any reference to the international legal framework which is specific to disability and rights. Specifically, I mean the UN Convention on the Rights of Disability and its most salient features, which is prohibition of discrimination, including a duty to provide reasonable accommodation, not just in the fields of employment, which is where EU law currently takes us, but in all matters affecting the individual. And even related to this, the Pact shows a complete invisibility of the EU's own framework for the rights of persons with disabilities, whether this is in the form of the prohibition of discrimination in the Charter, whether it is in the form of the right to the integration in the community. And at face value, one might say, well, does it matter so much that the pacts don't contain any reference to the CRPD? Are we expected to mention all interpretive instruments and all the obligations that apply? And those which arise particularly from international law. And yes, it's true, except for 2 points. One, remembering the status of the Disability Convention as a treaty that has been, that the EU, which the EU is a state party to, and which therefore means that at a minimum, the instruments of the pact must be interpreted in line therewith. And that, at the same time, the pact is peppered with references to the UN Convention on the Rights of the Child, to the principle of the best interests of the child. The Refugee Convention, of course, we've known that for a long time, but I think the increased references to the principle of the best interests of the child and the duty to take this into account is quite a development. And yes, once again, this reflects the emphasis that the Court of Justice has given this obligation, but it has also, the Court of Justice, reiterated the importance of the Istanbul Convention on Violence Against Women as a treaty which the EU is a state party to. So where is the CRPD and why does it matter? So it is also important, right, that despite the absence of this in the legal framework, the materials around the implementation of the common European asylum system have shown progression in referring to disabled refugees. So whether you look at the EU EASO's materials, which reaffirm the CRPD as key in interpreting obligations affecting disabled refugees, the Fundamental Rights Agency, you see them bring together the CRPD together with the Charter rights and the constitutional framework that really speak to the rights of persons with disabilities, including the European Disability Strategy, which the Commission gave us 2021 to 2023, which was specifically, or at least when it was updated, it did include migrants and refugees in response to how these were historically absent. Why does it matter? There are clear instances where I believe the CRPD can be instrumental in providing a more rights-protective understanding of disability. Because if, as I outlined in the beginning, the access to special guarantees is going to be dependent on who gets identified as vulnerable, who gets identified as disabled, is going to be a really important question. And this is where it is crucial, I would say, to identify who qualifies as disabled for the Pact's purposes by reference to a definition that incorporates those who, and I quote here, have long-term physical, mental, intellectual, or sensory impairments, which in interaction with various barriers may hinder their full and effective participation in society on an equal basis with others. What does this mean? It means endorsing and embracing an understanding of disability which acknowledges the role that society plays in disabling that individual. I think we can see many instances as to how in the asylum procedure, for example, someone can be, let's say, a failure to provide a sign language interpreter, for example, to someone who needs it, obviously effectively hinders communication and precludes the individual from presenting their case, their situation. But this also applies to the much broader category of individuals whom we haven't traditionally thought of as being disabled refugees, which includes persons with mental health needs, mental health care needs, who would otherwise also be recognized as psychosocially disabled, neurodivergent individuals, and I refer here to our wonderful speaker at the beginning who gave us an example of how an autistic individual was specifically negatively assessed, their credibility was negatively assessed purely on their presentation. So an expansive understanding, which is, the Pact doesn't go counter to this, but you will see in the various definitions or in the various inclusive lists of vulnerable individuals that are provided to us in the different Pact instruments, you have disabled persons that are provided as a category. You then have persons with either serious mental illness or persons with mental disorders. You have persons in need of mental health care support, for example, including PTSD. And it is important, yes, to acknowledge these populations, provided, or at least I would argue, that we acknowledge that these individuals then are entitled to the disability-specific protection, which is an entitlement, an obligation to provide that individual with an accessible procedure and a duty to provide reasonable accommodation whenever it is needed. And not just as a matter of discretion, as a matter of charity, but as a matter of obligation. From the point of view of the CRPD, we do have a specific article, Article 11, which speaks about situations of risk, which even the EU in its dialogue with the UN Committee on the Rights of Persons with Disability accepts, applies to the Pact and to asylum procedures. And so there is a clear link that can be made, and I would say should be made, in how all of this is interpreted and applied when the new Pact comes into force. So there is a way to counter that invisibility. But I would say, and this brings me to my second point, they become shorter as they go along, which is that the value of anchoring the obligations in disability-specific protections rather than vulnerability and the language of vulnerability as it is found in the Pact means that you no longer need vulnerability at all. So the redundancy of vulnerability in the face of anchoring rights in a disability-specific framework. And this, I would say, makes a significant difference because, as we've heard, there are various ways in which, when thinking about vulnerability, limitation, screening, or judicial review, which refuses to engage with the adequacy of the screening procedure, cementing the violation or the treatment as a violation of the prohibition of discrimination through a failure to provide reasonable accommodation makes a significant difference. It makes a constitutional difference, right? Now, of course, prohibition of discrimination, denial of reasonable accommodation is not absolute, but it provides an anchor that is much more has been taken away from the realm of discretion, not that vulnerability should be, but it makes vulnerability redundant as a mediator of rights. So it becomes, in the same way that the provisions relating to children speak of the best interests of the child as an autonomous provision, and not only, right, the guarantees for minors are seen as being different, and in addition to all the other provisions of disability, of vulnerability, when it comes to disability, this is not just a lovely thing to have, but this is also impelled by the EU's own obligations when it comes to the rights of disabled persons in general. And it's true, the pact integrates disability within vulnerability, and it's true that disabled migrants, refugees, applicants are always mentioned as one of an inclusive list of individuals who need additional support, but there is a value in framing their claims differently, and not necessarily in the language of vulnerability. I can understand from a practitioner's point of view why you might use whichever vehicle you have at your disposal, but I think there is merit in reaffirming the entitlement and its origins. So my last point to conclude then is absence. I've spoken about invisibility, the redundancy of vulnerability, but the next one would be the absence of any introspection at all in the pact as to the myriad ways in which the provisions of the pact itself create disability. And I would say, as in, this seems to be not only completely off the radar, but I would say the consensus so far has been that the pact will inflict harm, and that level of harm establishes a lower baseline. The system is built on an acceptance that a certain level of harm is acceptable. If this were in the case, we would not need exemption from specific procedures. We would not need an exemption from the relocation procedure. You know, it just, at least my brain wouldn't be able to compute that. And this is where we can't perhaps rely on an obligation, although you could say that the obligation of accessibility is this, but the model, I think, here of disability rights gives us a way to think about the pact and scrutinize the extent to which it causes harm. And this is the state's obligation not to create further disability, and the state's obligation to not only address disablement as it arises from barriers, but the state, in this case the European Union, to dismantle those barriers in order to create an environment that is less disabling and ensures accessibility and participation for all. Of course, extremely truncated procedures, as Minos said, Vasiliki outlined the emphasis on speed. They don't benefit anyone. They do have a disproportionate impact on disabled refugees, but they do impel a need to question and think beyond the current model. I conclude by saying that I have felt like, I always feel like the harbinger of doom whenever we're speaking about the pact, but I do think there are ways of thinking about it in a way that is more than just, that is thinking about the bigger picture. And for me, the bigger picture here, beyond what I've mentioned, is also one that calls for participation, one that calls for the participation of disabled refugees and also disabled persons organizations. In acknowledgement that I was speaking of disabled persons as if they are a monolith, they are not. it's very difficult to speak of one disability or one group, but this is where I believe participation by the persons who are actually affected by the decisions and the implementation being taken can provide the transformation or contribute to the transformation that is needed. Thank you very much.
Nicolette, for giving us another perspective, and one which I think is very, very interesting and merits more examination about the transformation of vulnerabilities into disability in order to be able to access the international legal framework to which the EU is party. We've seen the Court of Justice being increasingly willing to take into account any international agreement to which the EU has authorities. It's a really interesting approach and something which may provide some good tools for work expected impact. I'll now come to our third and final speaker in this section, Nancy Vitsikeri, who is a human rights lawyer with an academic and practical specialization in refugee law and international children's rights law. And you are a strong advocate of children's rights, you're child rights experts, and you're also a strategic litigator before EU institutions and also the UN treaty bodies. You are the director of an NGO, Defence for Children International Police. We all know Defence for Children International, which has provided us with the most important case law to European social policy in respect of socioeconomic rights. And without you, that those cases will never ever have come forward, as in I spoke to lawyers in the initial DCI case who said that he'd been to every single NGO, nobody would touch the question with a barge pole, and DCI said, so very important NGO. And you're going to tell us about children in
Thank you for this introduction. Can you hear me well? Okay, excellent. I'm very happy. I'm the last speaker. I hope you still have some energy. I will try to wrap it up a little bit because we all touch upon vulnerabilities. I would like to thank Vaso so much for putting this together. Vaso is really has been really supporting grassroots organizations in Greece. She's also teaching with us in our Human Rights Academy in summer school, and it's a privilege to be amongst all of you. And thank you for hosting us at your center today. It's very important for us who are in practice to really be given the platform to disseminate and share what we really see in practice. So I will try to give you the child rights perspective. Many of the things have been already shared from the other panelists, so I will mainly try to give you some insights of what is happening on the ground and to wrap it up a little bit and go back to the EU Asylum Pact and see what are the main concerns. I would like to start by taking you to one of the Greek islands, the island of Lesbos, which is one of the border islands, and to really share with you a story. As a practitioner myself, some years ago, I once met Sami, a 14-year-old boy from Syria who had suffered serious traumas because it happened for him to be next to one bomb explosion in Syria. He had to travel alone to cross mountains and seas, to take this dangerous journey that you very often see on the news, and to arrive in Europe alone. As you can imagine, he had already survived the unimaginable, and he was expecting to find refuge and protection. However, he was registered as an adult from the authorities. There was no vulnerability assessment, no best interest of the child, of course, assessment that took place, and he was referred to the main camp for adults. There, he was gang raped multiple times. At some point, he decided that he couldn't get along with this anymore, and he went to the police to report the incident. The police advised him to go back to the camp to negotiate, to accept the apology from the perpetrators and to continue living there. He was sleeping roughly out in the streets. The case was referred to us by a medical actor, saying in the referral form that no child protection actor could take over the case because he was registered as an adult, so they couldn't shelter him. We brought him to Athens. We went to the hospital. We went to the juvenile prosecutor. Again, the same argument. Sorry, he's registered as an adult. According to law, there's not much that we can do. The story goes on. I'm not going to get into more details, but in the end, he's safe now. He's in a shelter. We had to really fight against many deficiencies and bureaucracies. Sami is not an exception, unfortunately. We do encounter many cases like that, and we feel very often that these cases face the deficiencies of the asylum system, but also the fear and the agony that we all of us share with you here today, knowing that the EU Asylum Pact is coming. So let's go and ask the question whether the Asylum Pact is a fairer system and whether the child protection and the peculiar needs of children are at the center. Let's start unpacking the EU Asylum from the child rights perspective. As it has been already mentioned before, it does introduce a mandatory pre-screening phase. Does not exclude children, not even unaccompanied minors on the move. What does this mean? It means that the children will be detained for the 7 days, as they say. Let us, we don't enter this field blindly. We have the evidence and the experience of the past, and we have the right to question and to really share doubts whether the detention will only last 7 days. Of course, the pact sets some detention guarantees, specifically when it comes to the case of children with families and unaccompanied minors. They have to have an open space, children need to have access to education and a variety of rights. However, at the same time, the pact says that the state have the right to derogate from these requirements and guarantees if they find it necessary. And again, here, as also has been explained before in other paragraphs of the pact, we will have to identify and to define what actually means necessary, where the necessity lies for derogating for such guarantees. Secondly, the screening regulation includes no reference or provisions regarding the age assessment or the principle of the benefit of the doubt. If we wanted to interpret it logically speaking, this should be understood to mean that there is the presumption of minority for all those who claim that they are children. If this is not the case, then as Vas also said before, we really need to be alert in order for these people not to be referred to the fast-track procedures, unless there is an examination of their age. If we had the privilege to doubt the age of Sami in due time, Sami wouldn't have experienced these traumas. Of course, this is interrelated with another aspect, which is access to legal aid. It's not crystal clear from the pact whether legal providers would be able to reach the people during the pre-screening phase. And this is an open window for us, being practitioners and lawyers, to really have the chance to offer the services to the people. Another matter is that we really insist on this very pre-screening phase because, as already explained, it will influence the asylum determination process. Because in the end of the screening phase, there will be this pre-screening form. And we all know the critical role that this form is going to play. Already we experienced this with the registration forms, and in the past also we had pre-registration procedures. It happened 10 years ago I was an UNHCR, a dedicated member to the Asylum Appeals Authority in Greece. So I remember very well in the committee with the rest of the members that they were opening the file, and then it was a cross-checking between the registration form and the actual interview of the person. It does create standards, and people are trapped in these questions very often without really knowing how to go about this later. They might share that, for instance, yes, we want a better life, and this might be interpreted as an economic migrant who decided to leave the country, although if you want my personal opinion, it's a very gray zone, the forced migration and the asylum protection, but this is for another seminar. Also, we have already explained and shared that children won't have access to these procedural guarantees and no access to vulnerability assessment, but when it comes to children, they won't have access to the best interest of the child assessment. I'm going to devote a part of my talk later specifically on the best interest of the child, because this is what might make the difference. The Pact, as we said, establishes fast-track border procedures that apply to children with families, but not to unaccompanied children on the move. This is the good news, at least. However, I would like to take a moment and really shift the focus on this category of children who are the mostly neglected in our discussions, in our debates, in our policies, and very often to our programs organizations as well. This is the case of the accompanied children on the move, the children with families who make the 80% of the global refugee population, refugee children population. Very often, of course, states like to present their programs about the unaccompanied minors. And indeed, in Greece at the moment, we have good practices when it comes to unaccompanied minors. We fought a lot for this, Minos, many colleagues in Greece, in order to reach a place where we don't detain children anymore and we have reception guarantees. But we need to keep asking what is happening with this profile of children. I want to share you some insights. In the majority, there are children who are accompanied by a caregiver as old as 20, 25 years old, a single girl who has suffered unimaginable trauma, trafficking, FGM, extreme violence, gender-based violence, and they get pregnant along the way. They deliver kids in Greece or during the route, and they enter the country. These are children, I would say, transitioning to adulthood themselves with a lived experience as children of displacement, but also structural violence coming from the systems that we have set up for these people. These children live in remote camps. We visit these camps. These camps are in the middle of nowhere. The children have no access to education. Only informal education is provided to them. Very often they had no access to food. Believe that. Others live in the big cities in shared apartments with adults in precarious conditions. They witness the trauma and the abuse of their mothers. I'm saying this because in EU policy, the same in the EU Asylum Pact, we really see that we approach these children as an extension of their families, as an extension of their caregivers, but this should not be the case. Family unity, of course, is well established in the Convention on the Rights of the Child. We need to start from that. But in order to ensure that the best interest of the child and the family unity, we really fulfill this obligation, we need to care for this population as well. We need to care for their families. So, according to the EU Asylum Pact, all these deficiencies and the shortages that we described before, because they happen to the parents, they will affect the children. They will be detained. We already have the reality of de facto detention in Greece, and not only in Greece, all the hotspots. Let's be honest and let's name it as such. It is detention, but it is de facto detention. And we're afraid that this will be prolonged and this population will be trapped in detention centers. You can imagine another point I want to make. I will be brief because this opens a big chapter. It comes to the refugee status determination. We as lawyers and practitioners, we need to keep asking for thorough and separate assessments when it comes to children. We very often receive asylum rejections with the legal reasoning about why the mother or the caregiver should be deported and does not qualify as a refugee, but there is not even a line about the rights of the child. So this is really, it is an unjustified decision that we can challenge later on before the courts, because according to law, the CRC Convention is the most widely ratified convention. It is national law, it is European, it binds European states. Saying this, we really need to discuss the EU Asylum Pact in the broader framework of the international human rights law. If we don't do so, I'm afraid we will really fall into the trap of really having conversations that are exhausting in the crisis management, and the discounts are going to be great. As you can imagine, the impact on children's rights is tremendous, of course, and on their mental health and their well-being. Studies show that even a few days of detention of children can really influence their physical and mental health integrity. On top of that, for a child, with families or not, being in contact with the justice system, because administrative justice procedures, asylum procedures are part of the justice system, on itself can be a very challenging process. No access to information, no training, no specialists who know how to speak in a child-friendly language and approach to children. Of course, the regulation has thought that these are concerns, and it tries to ease these concerns by repeating in different points that the best interest of the child will be the guarantee. And in the implementation checklists that have been already shared with the states, asks for states to develop SOPs, develop protocols, methodologies, how this will happen. However, in these fast-track procedures, in the pre-screening procedure of 7 days that we don't even have a vulnerability assessment, really, are we going to have a thorough best interest of the child assessment by specialists? Let me have my doubts when it comes to this. The best interest of the child might be the solution because it is a guiding principle in the text of the Convention on the Rights of the Child. It is a right on itself. The children have the right to have the best decision for them, but also is a procedural right, which means that any process and any examination and any decision affecting children should be conducted in a way that is in line with the best interest of the child. My suggestion is that we really need to keep asking the right questions as academics and as practitioners. When it comes to children, we really need to keep asking, why is this in the best interest of the child, and challenge these cases? Because normally I did research for 3 years in case law about the best interest of the child concept. I didn't find any decision really having a legal reasoning about this. It was a mere reference to the best interest of the child. So we really need to ask from the states to explain and to analyze why this is in the best interest of the child, in order also to develop some standards. Detention will happen. We need to speak also about alternatives to detention. There's a lot of work about that. Community solutions. There are best practices, and we should start discussing in this regard, because prolonged detention will be the case. I will close by making a more general remark and saying that we all know that the times we're living now are very challenging. We see far-right policies. Also, Greece is suffering from this symptom big time at the moment. And I think what we are going to see with the EU Asylum Pact is not just a set of legal reforms. I do believe that it's going to be a test to our core values as a European society. And we need to keep involving in our conversation universal concepts, such as humanity, such as justice, and such as dignity. Not only for the case of children, for the case of all the people who flee their countries for any reason, and they reach our countries in order to have a fair access to justice. When it comes to children, of course, I must say that childhood delayed might be childhood denied. Thank you. Closure to our presentation, bringing it back to the realities of what happens to child disability or disability. Come back to that. It's a vulnerability. Right, that's something that's hard to think about that a bit further. But I think it's really you've outlined how much work there needs to be done in order to ensure that the implementation and application of these measures actually do not harm further those who come in contact with them. I think it's certainly
very worrying development of the law that we can acknowledge that we will accept procedures which cause harm and perhaps limit that harm, but only for certain persons. And then the difficulties of children in being able to access these techniques. They have policy. Okay, it's now, I think now it's time for you to ask questions of all of our speakers. I think we probably have at least still half an hour, maybe more as time goes by. We didn't do any questions up until now, so you can ask everybody questions. Everybody's still here. For those who are online, I think there are already 2 questions that you let us picked up. Does anybody want an order or should we let online crowd? Well, let the online crowd get, but I mean, they usually get the worst time, so we can always start with them and we've forgotten them by the time we get to the end, and then we'll come back. Would you like to ask a question? Is anybody else who wants to offer this at this point? Okay, we'll leave it there. Can you read out the question?
Yeah, sure. I will. So from Evangelia Papada, thank you very much for very interesting presentations. A few thoughts in the form of questions. In what ways is vulnerability instrumentalized as a smoke screen? The procedural derogation protection as the procedural derogation that protection seekers are experiencing. Let's not forget how vulnerability functioned during the EU-Turkey statement. What kind of border is implemented in Greece and in the context of digitalization of our surveillance in particular and generalized border procedures and hotspots hangover. So this in mind, are there processes at play or processes of outright dehumanization that you would like to highlight? I think it is important to put vulnerability and procedural guarantees in the context of increasing militarization and suffering on the islands and in the Evros region. So that's one. I don't know if you want to collect.
Should we do both questions?
Yep. So the other question is from Katie Lowe. Hi, I am a Queen Mary alumni, now volunteering with Border Violence Monitoring Network, so BVMN, with the advocacy and policy team. I was wondering which parts of the pact the panel think civil society realistically can have the most impact in challenging and campaigning against. Secondly, how does the panel, particularly those from other NGOs, feel that we can best collaborate to create a stronger regional resistance to the substandard nature of this pact? Would a new think tank to collaborate be helpful? The pact's consequences will be deeply felt far and wide, so thank you very much for your essential and interesting discussions.
Okay, well, that gives quite a lot of scope, I think, for almost everybody here. The first question was directed in particular to nobody in particular. Right, so who would like to come back to the vulnerabilities of smoke screen?
Sharon, if you want.
So I feel
We've been told that when you don't address your voice over there, they cannot really hear, so.
Okay, I will just briefly touch upon the first question, which I feel indeed, thank you very much, Evie, because it's indeed a very good question, but also for sharing your thoughts. And I have read your PhD thesis, by the way, on vulnerability assessment. And I have to say that indeed, we need to be careful also when we speak about this, because exactly what you mentioned in the case of the EU-Turkey deal, for example, the vulnerability was used as a way to exclude vulnerable asylum seekers from border procedures and refer them to the regular procedures. And this had been instrumentalized. That's indeed, I mean, the aim was not so much to have a good interview, but to try to be recognized as vulnerable in order to be referred to the regular procedure and leave from the islands. So it is indeed argued, and it is also mentioned in the MSS case, for example, that all asylum seekers are vulnerable, and special procedural guarantees should not be selectively applied to specific asylum seekers because they all these people have experienced trauma most of the times. So while it's true that fleeing persecution and seeking asylum is a difficult experience for everyone, it is also true that not all asylum seekers face the same barriers with accessing the asylum system. So the aim of the special procedural guarantees and the identification of vulnerabilities is not necessarily to create a hierarchy of suffering, that some people suffer more than others, rather to ensure that all asylum applicants have equal access to asylum procedures. This is, I think, what I wanted to mention. And for the second question, I will leave it to the people from the NGO.
Does anybody else want to comment on the hierarchy of misery? No, can I ask somebody to, one of our NGO speakers, to answer Katie's question?
Really digging this musical chair situation. So I think lots of interesting reflections and food for thought for sure. When we think about elements of the pact that we need to campaign against, warn against, and litigate and fight, I think there's definitely multiple levels. The way in which we've tried to sort of categorize the kind of avalanche of changes coming our way is what is blatantly contrary to international law and also to primary EU law. So what should be directly and squarely resisted and basically disapplied. So I think that gives us a very interesting field and an arena to really discuss the very basics of EU law that we all sort of recall from our studies. Areas where those regulations plus directive are actually not to be trusted and not to be implemented, because this would run counter to fundamental principles of the EU legal order that need to be respected. To me, a very good example, which is both something that looks like an integrated procedure, but also a really sort of foundational part of the asylum system, is anything that relates to protection against a risk of refoulement. So you'll see in the various provisions of the pact, namely the asylum procedures regulation, that are now to be coupled with an upcoming disastrous legislative proposal on a return regulation, there are multiple opportunities created for states to deport people before a claim is actually examined. This is done mainly through the vehicle of two things: combining as a mandatory practice the denial of asylum to a return order, because in the binary EU logic, if you're not granted asylum, you need to return. There's nothing in between. We know this, of course, to be divorced from reality. And in conjunction with this, denial of automatic suspensive effective appeal. So the very basic notion that is espoused by the European Court of Human Rights, but also by the Court of Justice of the EU, that when the person faces removal, which could expose them to inhuman and degrading treatment, an appeal needs to be suspensive. It needs to make sure the person stays until the appeal is actually heard. These protections are really chipped away by what's already adopted under the pact and what's going to come under the return proposal. And our advice or plea to decision makers, judges, lawyers, this is just unlawful. There's not any other way to describe this. A similar, to me, example is anything that relates to de facto detention, as we've discussed it. Interestingly enough, the pact talks about not authorizing entry to persons undergoing the border procedure, be it the screening stage, the asylum processing stage, or the return stage. The pieces of EU legislation stop short of admitting what this actually means. And the drafters of those laws have also refused or have been unable thus far to properly explain what that actually gives in practice. We've had this rather awkward exchange with the European Commission, the main drafter of these texts, already since 2020 when this was put forward. The response is, well, it's up to the member states to tell us how they're going to do it, because it's their obligation to now implement it. And then policymakers at the member state level say, well, the Commission came up with this, so they should explain to us what that means, because we don't know what that means. The result, I think, is quite clear. Through this obfuscation and through this sort of engineered ambiguity, the practice will determine the content of those provisions. And the warnings have been there since day one. It's clear this is deprivation of liberty. And if this is de facto deprivation of liberty, it's also arbitrary deprivation of liberty, plain and simple. Another category that probably creates some space for opportunity, albeit limited, would be areas where concepts have been introduced, I think, with a clear kind of intention on the part of member states in the council, the main legislative power, to not really give too much space for what's introduced, but nevertheless creating some sort of opportunity. We heard from Nadina, among other things, the importance of early legal intervention during the sort of initial stages of processing. One piece of the puzzle that is introduced was actually included in the last stages of negotiation is some sort of state-sponsored legal support or counseling, as the provision is now called, at first instance. That would mean that states have an unclear for now obligation to provide asylum seekers with free services of counseling before they launch, so before they fully register a claim for asylum. The provision is extremely obscure. It has no legislative history because it basically kind of arrived out of thin air during the last stage of negotiations. These are the so-called trilogue negotiations between Parliament and Council. And there's a very sort of wide space for discussion, but also contestation on how that could actually work. The early signs we've had for now from the Commission and Member States is that this in no way should be understood as legal assistance, because why would we give people lawyers to begin with? And that this is also something that could be done by the EU Asylum Agency, or that could be done by state authorities themselves. There's actually also rather tricky precedents in countries like Germany and Austria, where the decision-making authority, so the asylum authority, has specialized sections that provide counseling to people who will then present their claims to the asylum authority. And the view that is expressed by these member states is that this is functionally completely independent, because it might not be the decision maker who will advise the asylum seeker on how to navigate the process, but their colleague from across the hall. Our view, and this could be something to be explored further, is to channel these standards and these provisions through established orders, for instance, regulating the legal profession. Greece is an example among other countries where it is tightly regulated under domestic law what a lawyer can do or what services must be provided by a lawyer. Legal counseling under Greek law must be done by a qualified lawyer. So to us, the law is quite clear. The question is, how do we make sure this actually turns into practice? The last thing I wanted to say in response to how we can better organize, or whether we need, for instance, a think tank or some sort of forum to explore these points further, I think civil society has really demonstrated its willingness and its capacity to contribute to this fight and to really try to maintain and safeguard the standards. What I think could definitely be useful, and it's kind of the name of the game today, is to really look at the established standards at international level, to look at the justice system, to think through the lens of justice, of the rule of law, when it comes to not only the fairness of the process, but also protecting people against arbitrariness and abuse. To me, this can really lead us in a good direction if we trust it. Thanks.
Thank you everyone for really insightful presentations. It's just I have a question with regard to assessment of vulnerability again. Vulnerability, you said it's contextual, and if we do look at the context in Libya, everyone there is pretty much a victim of exploitation and trafficking, because smuggling is all together. All too often mixed with trafficking because of the context in Libya, and then how militias and armed groups are actually implicated in these kind of violations. So would that make us just like assume that everyone coming through the transit point of Libya, that hub, is going to be classified as a person with vulnerability, thus in need of kind of like exceptions or kind of like procedural guarantees, because that seems like the case. No one passes through Libya without being harmed. No one is not a victim. So that might be considered then on the European side as like, okay, this is what do we do about like this crisis management because of the arrivals? Then everything from Libya, they are vulnerable. So this is kind of like a burden on the asylum system. Just like wondering how query from the chat, if we can always speak into the mic, because otherwise they cannot hear us. Would you like to very briefly rephrase over there? Sorry. Could you also tell us who you are? I forgot to say, but everybody, please. Not everybody knows everybody. Some people know everybody, but
sorry. My name is Myrna Nasrallah. I'm a PhD candidate at Queen Mary University of London. So my question briefly is like looking at the context in Libya and the fact that vulnerability is always contextual. Oftentimes then we do need to classify everyone that is going through that route as like vulnerable because of the context that they've been through. And then how does this translate on like the EU side in terms of like, okay, everyone that comes through Libya then is going to be or like must be afforded these kind of like guarantees. So yeah, just thank you.
I'd like to address that.
Sorry, it's a long way. Thank you, Myrna. I think this is precisely where the whole issue of definitions comes into play, no? And who gets to be qualified as vulnerable within the categories of individuals who are entitled to special procedural guarantees or special reception needs, just like with the current system, there is an inclusive list, and this could potentially include victims of trafficking, people who have had experiences of torture, people who have post-traumatic stress disorder, for example. And I'm just mentioning the people who are explicitly categorized. And so I think as a textbook reply, that would be the way to, the fact that most people might have experienced that does not take away from the fact that they could be considered as vulnerable in that respect. But this is precisely one of the issues with vulnerability, no? And when it's when you have a procedure where vulnerability is the exception to the norm, as the person who asked the earlier question, it then becomes the only way out of a system which is designed to, or even if it's unintended, but it becomes the way out of a system that that makes the person vulnerable. So the extent to which that is going to result in true protection, I would say leaves much to be desired. Sorry, I know this is not a full answer. It's just, I don't know if my colleagues want to add to that.
Does anybody want to comment on Libya? I mean, I think there's also the question that somebody who may not have been vulnerable or have a disability, when they start the asylum procedure, by the time they get halfway through it, they may be seriously disabled by the process through which they've gone, through the constant questioning of their veracity. This is your credibility issue. You know, I think that anybody who's worked in practice will have seen this. You have somebody who's fairly coherent when you see them for the first time, but 3 years later, having been put through the machine, they're in need of serious assistance.
And this is one of the main issues, I would say, with vulnerability being assessed, for example, at the start, and vulnerability being treated as if it is something that is fixed and that without any consideration that it could be a fluctuating condition, right? So globally, the data is always that 15 to 16% of the global population is disabled, right? Because we also move in and out of statuses. There is nothing which says that you are, except for you are born a child and will become an adult, right? It is not as fixed. So fluctuating conditions, but also the impact of a procedure that does not take into account the individual is one that is going to result in a detrimental effect, whether it is mental health, whether it is, you don't need to have any specific impairment to be completely destroyed by years and years of waiting, or of being shuttled around, or of being left out of any kind of permanence in your life. And I suppose one of the most important things to remember is also that these are one layer of identity, right? We speak a lot about intersectionality, but there is nothing that stops someone from being someone who has experienced trafficking or who has experienced torture, and then also having other issues, whether because they are a person with disabilities, whether because they are, I don't know, whatever, right? So they might also be a child at the same time. So I think it's also important to see how these protection or guarantees speak to each other and are in conversation with each other.
Does that answer your question? Okay, we now have two. I'm going to suggest that Violetta, that you come up, and then if you, Ellen.
How is the question of vulnerability?
I think you have to come up here.
I can't repeat it. It's actually on vulnerability being a gatekeeping device more than something that will.
Violetta, if you don't come up here, the people online can't hear you.
I mean, I was So no, my question is actually on vulnerability being a gatekeeping device rather than something that is going to repair the ills of the system being so insensitive to discrimination and all manners of harm. And I was wondering what the panel had to say, in particular, Nicolette, on how now showing vulnerability by requiring proof from the applicant generates a procedure within the procedure, right? So it generates further complexity, and with that complexity, additional ways in which barriers and harm can happen. And actually what is intended to improve accessibility will be arriving at the opposite effect. It will generate more barriers to accessibility rather than improving access to procedures. And I think this goes to all of the speakers. I mean, in some instances, you will have to demonstrate disability. In others, it will be age, so that you are classified as a child. In others, it will be sexual orientation, so that you will be classified as an LGBTI applicant or a victim of torture. But what is interesting, interesting in a perverse way, is that by peppering these vulnerability references all throughout the Pact documents, rather than a return to the MSS standard where everyone was intended by default as vulnerable, we are generating an additional thing through which you access the procedure. Once you access the procedure, surprise, there's no guarantee that this is going to end well. You will still have to demonstrate age, disability, whatever, and then that you are also escaping or fearing harm, persecution, and so on. So there are like additional filters that are being introduced in this manner, very subtle but very effective. And I was wondering what the panelists would have to say. Thanks.
Can I start?
Yeah, you're there.
I mean, Violetta, I agree. But no, but the issue, well, there are many issues, but I will just speak about disability, right, in general. Specifically. One of the key protections or one of the key changes in disability rights is the move precisely towards what I call a social model, a human rights model, which is that you do not conceptualize the disability as something within the individual. It's not about the impairment, but it is about what is missing or what are the barriers that preclude you from actually enjoying your rights. And looking at the pact, it might seem, or at least it seems, like it is just one barrier after another, and the vulnerability procedures are a way of getting access, not to something where you can fully enjoy your rights, but to a procedure, to a system that is still designed to create as many obstacles as possible. So for me, when we speak about disabled refugees and the right to enjoy rights on an equal basis with others, I think it's important to return to the Committee on the Rights of Persons with Disabilities, for example. It's not, and some exchanges with the Commission, it's not about the right to enjoy your rights on an equal basis with other migrants, refugees stuck in the abysses of the pact, but it is with other human beings in general for whom their humanity is prioritized over their migration status. So yes, that I think partly answers it.
Thank you very much. Does anybody else want to come on? Okay, first here and then you.
Thank you, Violeta, very much for your question. I was also thinking this when I was trying to organize this event and have this title, but because I also agree in many respects. But what exactly we see the last years, especially with the EU Pact and the discussions, because I was constantly following the negotiations, is that indeed the focus is on having very strict procedures, very fast procedures. And I think that in this specific time frame, the fact that still we refer to special procedural guarantees, it is important. And first of all, just to refer first to the way these are certified, it's certified through a medical check and through a psychosocial assessment, which entails an interview with psychologists, with social workers, and this is done for everyone. So it's something positive. I will start from this, that we need to have these assessments. Everyone should have access to psychosocial support. I mean, now exactly as Minos mentioned, there are cases that there's not even a medical check before the interview, not to mention the psychosocial assessments. I mean, most often they are omitted. Now, the psychosocial assessments are conducted only for those who are considered vulnerable if the doctor has said that. So at least now we can speak of thorough vulnerability assessments, which entail both medical checks and psychosocial assessments, which aspects can be used in the interview. Now, regarding the special procedural guarantees, as I mentioned, it is important to have them. If you ask me, of course, I would say that the border procedures, for example, are substandard procedures for everyone. I don't think that they can be procedures which have safeguards for any one of the asylum seekers. I mean, the focus is on speed. How can it be assessed in this time frame whether someone needs protection from persecution? But and this is why I think that we should insist on accepting vulnerable applicants, which, as Myrna mentioned, I think, yes, it can be the majority of asylum seekers, and we have seen it. We have seen it, as we mentioned also in her interventions, that many people were exempted from the border procedure in the past, while after the new legislation, for example, in Greece, no one was exempted from border procedure. At least with the vulnerability assessment, we had many asylum seekers that were referred to the mainland and to the regular procedures. Of course, we need to take care that to make sure that we will not neglect the asylum seekers who are not considered to have special procedural guarantees, which are just additional safeguards. And we will still advocate, of course, to have efficient and effective asylum procedures for everyone and adequate reception conditions. For example, no one should be kept in detention. The detention or the de facto detention context is not appropriate not only for applicants with special reception needs, but for all applicants who are coming here. So yes, I think we can still speak about special procedural needs and exempt applicants in order to ensure that everyone has equal access to the asylum procedure, because I think equality is also exactly speaking that everyone has equal chance to exercise their rights, and some who are most vulnerable may need more safeguards. This is something true, but on the other hand, we should not neglect, and I think also this is why we mentioned that also civil society actors focus on all asylum seekers, and no one should be excluded indeed. Thank you.
Thank you very much.
Yes, thanks very much, Violeta, as ever. Two things I wanted to say. definitely agree, and I would bring back Elspeth's point on how this entire discussion and the way in which vulnerability is conceived and presented through law and through practice does give us evil, nefarious system, but exemptions for specific categories from this. And I think the symbolism of this is unfortunately so powerful because not only does it cement the view that the asylum system is inevitably a negative experience, it is inevitably something that is very difficult and should be deterrent, should be sort of very strict, unless you manage to be one of the ones that is somehow given a softer treatment. But in a twisted way, it kind of gives the same very, very twisted and very negative perception of the refugee themselves. And to some extent, there's also an unwitting participation in this narrative from humanitarian actors themselves. This may be a very personal account of things, but whenever I read a UNHCR report piece that says 10,000 people, including that many children and women, I understand where this is coming from. But what that contributes to as a narrative is that the men are bad people in some way, or that we need to highlight that this group contains perhaps some subgroups or categories of people that need to be exempted from the overall view that would be afforded to that particular population. And I think refugees being, the sort of classic scapegoats in any type of populist narrative in any country, we've seen this play out all too often. One other thing that I think has also emerged from the conversation is a bit of a dichotomy between how structured, systematized, and category-based tick the box the identification of vulnerability is on the one hand, versus how unclear, ambiguous the result of this finding should be for how the person navigates the asylum process. We have some exceptions that we mentioned through past or perhaps even current practice, such as evading a particular procedure, right? Channeling to a normal procedure rather than a border procedure. Or when it comes to unaccompanied children, it's quite clear that this would mean being appointed a guardian if things go well, being channeled to a specific type of reception structure that would not be encampment for a country like Greece. For other parts that include, I think, all of the discussion of procedural guarantees that should be specially designed for people with vulnerabilities, but even some reception aspects, the ground is very unclear for states and also for the people navigating the process. That leads many countries and many systems to put forward the view that they can cater to any potential need in the normal running of the system, which leads us to the scenario where a country like Greece says everybody in any procedure has access to special procedural guarantees, because they just do, because we interviewed them, because they appealed their decision, so everything is actually working out fine. And we have similar examples from reception for, again, groups that may not be as sort of clear-cut as an unaccompanied child below 18, so goes to that system. And to give a bit of an anecdotal side of the story, we have represented different cases of people with different profiles, of course. We had an example of a single-parent family where both parent and children had sustained very severe forms of trauma, had very acute needs for mental health support. And we asked one of the camps where they were staying in Greece for special reception needs, following the process that is designed in the law for this to be claimed and for the person to receive special reception conditions. The response we got back was they're actually already getting special reception conditions because the room in the rub hole where they're staying is the closest one to the bathroom. So that's a special thing we just designed for the vulnerable ones. And the state, even in official discourse and official figures provided, says at the end of 2024, for instance, we had 27,000 people living in camps. This is the only form of reception that is afforded unless we're talking about unaccompanied children. 4,000 of them were vulnerable and had special reception needs, and they were receiving those in the very same camps, in the very same living conditions as everybody else. So the question would be, what are we actually talking about? What actually is a special reception condition? What is adequate support? And how can this be assessed and adjudicated? Because unfortunately, practice has sort of demonstrated that states are not really interested in this. And I would even go beyond Greece. I think for most member states, this has been probably the trickiest standard to actually implement and enforce. And we're definitely more likely to keep seeing this in the future.
Thank you very much. I think that's a very worrying scenario. Do you want to speak to this? Okay, come speak to this, and then I've already recognized you. I recognize you next, and then you're a third. And we'll bunch all three questions together. So you'll have to get up and bounce up here so that the people online can hear.
I would briefly want to add something, although I know that may be a bit disorienting because I'm not speaking that much from a legal point of view now, but more from a decolonial perspective. So reflecting on vulnerability and queer asylum seekers, basically what we see in the process is how SOGIESC asylum seekers are expected to reproduce this idea of the vulnerable subject, how they are expected to inhabit this position of the vulnerable subject, who is in need of protection, who is agentless, who is expected to be rescued, let's say, from the benevolent European countries. And this is how the West idealizes itself through the asylum system, which we need to think like how much of a colonial structure is asylum system in our discussion about a fair and inclusive asylum system. So yes, basically what I try to also explain through the presentation is how applicants are expected to inhabit this position of the vulnerable subject, and how this erases complexities and nuances in their accounts, and also leads to unjust decisions, basically. People who are being persecuted in their countries because they express that they have not passed through this difficult and painful self-realization process are being disbelieved. Yeah.
Thank you very much. Could I ask you to come up and
Okay, yes, I'll keep that short. So my name is Ellen Alda, and I'm a PhD candidate here at Queen Mary. My question is both kind of based on also my practice and working on Samos in the CCAC, and this question of what substantively is vulnerability. So of course this is building on kind of where we've been going in the conversation of, you know, what does that recognition of vulnerability actually amount to? And I'm curious to see other experiences from the NGOs of, you know, once a recognition of vulnerability happens, once vulnerability comes into play, does it actually offer any substantive protection? In the context of the Samos Closed Control Access Center, vulnerability was very much a classification that didn't officially come into play, but we saw it unfolding in the context of people being moved from the island. But they'd be moved to places that were very remote and that didn't actually have any access to substantive protection or legal actors, notably. So a lot of these locations were very, very remote and they didn't actually have any legal actors. It was primarily humanitarian actors in those spaces. So the vulnerability, you know, is it actually offering any substantive protection, or is it just offering this kind of benevolent classification? Same thing goes for the EMA referral mechanisms for those who are survivors of human trafficking, that this kind of, are we actually seeing any substantive protection emerging from the recognition of people as survivors of human trafficking, or falling in within any of these kinds of classifications, categorizations of vulnerability? And so I'd be really interested to hear your experience if you're seeing it offer any kind of form of substantive protection, if it's supposed to be this kind of pathway out of the enhanced border procedures.
Thank you very much. Just before you're next. Good, comes up our questions here. Come up here, Jess.
Hello, my name is Nana Onu. I'm an alumna with a few of you, and I've been on your courses also. So my question is essentially about, because you mentioned that in your presentation, I just wanted to hear a bit more about the so-called safe countries. and how basically these standards or substandards established by the new pact were being enforced, if you thought that they were being reinforced, addressed, and how do you articulate your work basically with the organizations that work in those countries where the EU basically just externalizes border control. Thank you.
Thank you very much.
But I didn't plan to talk in front of microphone. But so I'm Maria Gruch. I'm a postdoctoral researcher from European University of Viadrina and a visiting scholar at SOAS at Nicoletta's School. So I have a question about something that was mentioned in the first question. It's about digital infrastructures and these investments of European Agency of Asylum in digital interfaces to assess vulnerability. And there is a trend in doing this. There are two tools that are developed. One is called Tool for Identification of Special Needs. The other one is called Tool for Vulnerability Assessment. And I have been following their development, and I wanted to ask the practitioners from the field how much you have already encountered these tools. And in description of the tools on the European Agency of Asylum website, it says clearly and explicitly that they are there to support assessment, like in this screening phase, without expert knowledge. So who is using this tool explicitly says doesn't need expert knowledge, so it means it will circumvent or support the lack of experts on the ground. So my question is how much you heard about this? Is it used? And will it actually maybe help record some of these irregularities that you mentioned and maybe help later challenge some of the decisions? Yes, thank you.
Thank you very much.
Excellent presentations. I'm not a legal scholar, and I could follow everything.
Oh, that's
Everybody worried.
But it doesn't mean that you're bad at work.
Were there any other questions? Because I think this is going to be our last round.
I can address maybe the vulnerability question.
Okay, I'm going to give everybody a chance to speak, because this is your last opportunity, and hopefully you'll address the speakers. But shall we go in reverse order and start with you, please?
Thanks for the question on the vulnerability and the need for having vulnerability assessments and whether this really leads to protection safeguards. I would like to bring another dimension in this conversation. Of course, we speak about procedural guarantees, about reception conditions, and also for protection needs. And indeed, people who are qualified as vulnerable, indeed, we have seen them with serious health issues that they are transferred to the mainland, so they have access to the hospitals and to medical support. We have seen pregnant women also being able to be in better places and so on. But apart from the protection needs, I think it's vital to engage in our conversation the impact of such an assessment on the very essence of the asylum determination procedure. And for that, it's important to maintain such vulnerability assessments. For us as lawyers, you know, for someone to qualify as a refugee, there are specific grounds. One of the ground is the social particular group, for instance, where is the women, sexual orientation, also children that have encountered different kind of forms. And there sometimes, in order to be able to build your legal argument, you need really to bring evidence about the discrimination experienced by this particular group in the country of origin, and very often through the torture identification. This is a way out for us as lawyers in order to be able to establish this, not only for the social particular group, but also for the other grounds of the refugee status determination. It's like it provides more of a proof in our work in front of the asylum authorities. So even if the person fails the credibility assessment, this kind of evidence, it really reinforces the narrative of the person. Also, we deal a lot with subsequent claims, exactly because we don't, in Greece, I would say the NGOs that are on the ground at the moment offering legal support, the capacity is limited when it comes to the needs, and will be also in the days to come. So many people are deprived of access to legal support, which means that we also have a lot of rejection. So in our organization, we really deal with subsequent claims. It's not easy to reopen a subsequent claim. You have to prove that you have something, you have a new element to bring and why you couldn't bring this element before. So we really try to use the torture identification, trafficking identification, or the harmful experiences of the person in order to be able to reopen the case. And we have great success when it comes to this. This vulnerability assessment really supports so far all this procedure. Another point I want to make related to this, but also as a final point, is that we have been discussing procedural guarantees and also the guarantees in place. All this won't be effective if we are not going to couple this with well-trained staff. This is vital. The trauma-informed approach should be integrated in every training. Every person that comes in contact with an asylum seeker, no matter if the person is a child, no matter if it's a man, they need to be trained in the trauma-informed approaches. And why? Because very often, all these vulnerabilities and these harmful experiences that for us is very easy to define them into the legal framework as abuse, as a serious violation, as torture, they're not aware of this. I will tell you that very often I will never forget the encounter of a 15-year-old girl, the way she collapsed when she realized that being raped is not okay. She grew up in Congo, and she literally said, but I've been always remembering myself being raped in the neighborhood, everywhere I've been through. So FGM as well. FGM, female genital mutilation, is not crystal clear to the refugee women that this amounts to torture. So it's also very, very important to keep investing in this. Otherwise, I'm not sure whether we will be able in the end to offer the protection that we're aiming for.
Thank you very much. Nicolette.
Going to be very brief, just hearing these final interventions and questions. For me, the word that keeps coming up is solidarity, and solidarity not as has been instrumentalized and understood and discussed in EU law, but solidarity as a way of rising above the categorization of vulnerability and remembering the multiple dimensions of our identity that we inhabit as human beings. I think today we have been deconstructing that and reconstructing it in some ways to see how the new pact will affect it. But I would say that going forward beyond and it's extremely important to have trauma-informed approaches in assessments, etc. It's also about how people will experience the procedure, how people will experience the pact, and the extent to which that will also have an impact on how they negotiate their own identity. So I don't have any hopeful words except things to keep in mind. Thank you.
Bringing us back to ourselves and our own obligations in part of society. Sophia, would you want to make any final comments? Okay. Milos.
Take on the safe their country questions.
We have news.
Breaking news
Yes.
from Greece.
Every time somebody says save their country, I magically appear. Sorry, you've already put up with me for way too long, but maybe starting with the question of the EUAA tools and acknowledging that the agency has, I think, progressed quite a bit in producing materials that are increasingly useful to mainly to officials at the level of the different member states. Specifically, when it comes to identification of vulnerabilities in a context such as the domestic system in Greece, I would say that because vulnerability identification, whether on the islands or beyond, has been more or less medicalized as a process, right? It's a process that goes through paperwork and it has to have a medical professional stamp in order to be kind of officiated, we as practitioners do not necessarily see any potential impact of those tools. We wouldn't be able to know if they're used or not in the process, but quite often the status of a woman as a victim or a survivor of torture will be attested by a urologist stamping a paper. And for the system and for compliance with legal standards, that's good enough. That's the necessary process. Safe Third Country, to me, always in the back of our minds, because it's not only the cornerstone of this new pact reform, it's really the driving force of change of the EU legal order to go to a place where denial of asylum to refugees will be a stronger possibility for states. This is the quintessential category of tools that states apply to deny protection to people who actually need and deserve it, right? And it usually comes with a political admission that the people caught under the web of the Safe Third Country policy are the very people who would definitely get asylum if they had a fair chance of having their claim heard. To give you an example, Greece has been one of the countries, the few member states that has listed specific countries as safe third countries. Another one is Hungary, always in great company. And Turkey, after the EU-Turkey deal, but especially after 2021, with clear legislation on the matter, was designated as a safe third country for specific nationalities, mainly people from Somalia, Syria, Afghanistan. The people for whom it was, let's say, crystal clear that a positive decision would otherwise be granted. As of Friday, the list has been quashed by the highest court of the land. This was a case that was brought by our organization together with the Greek Council for Refugees. We're very happy for now, although we brace for the worst. But one part we definitely grapple with, and we've consistently dealt with throughout the Safe Third Country litigation, that basically becomes as demanding and as resource consuming as Dublin litigation in a country like France or Germany, where you have an entire side system that deals with refugee litigation without ever touching actually the refugee claim. You still have to deal with everything that comes before. Vulnerability is such a big part of it, not only to discuss aspects such as border procedure or regular procedure or how the processing should happen, but really the gist of whether a country could qualify as a safe third country. And to me, this conundrum really speaks of the very, again, rudimentary approach that is followed by states and by EU law now, per which safe third country is an admissibility assessment. It's a very quick yes or no answer that could be given in the blink of an eye, even though actually this is an asylum procedure of its own, to decide whether a person that has sustained torture or other forms of trauma would have access to rehabilitation services in a country outside the EU where we have extremely limited information. That requires a very, very careful, a very thorough assessment. And all too often, these things get overlooked, not only at the stage of designating a country as a safe third country, so listing Turkey as a safe third country for certain nationalities, but also in decision-making itself. So we very often have to rely on the ability of decision makers and judges to actually open these case files properly to have a thorough assessment. And very often, vulnerability will be used as grounds to put forward a claim that a country cannot offer the level of protection that would be required. I think the points that Nicolette made about the CRPD, again, transferable to other types of international instruments, Convention Against Torture, Convention on the Rights of the Child. These are really, I think, interesting ways for practitioners to develop the kind of thinking further, to say, yes, we have safe third country criteria that look relatively limited in scope, but if you actually construe them in line with the international human rights obligations and legacy of the past many decades, that actually creates quite a powerful set of rules that can be quite onerous a threshold for a country to meet. Final point, because I've rambled too much, kind of bringing it back to us and also bringing it a bit back to academia. To me, never has the dissonance between current law and political decision-making and academic research been so vast. I think academics in the asylum field have been too used to their views being considered, being acknowledged, and then discarded, and politicians coming up with something completely different that denies research. But I think the absence and the contempt for evidence is greater than ever before. Lawmaking, not just a finished product of a piece of legislation, but the entire process of developing standards has been so divorced from reality, from evidence, and from research that this to me is a discussion that we need to have as a standalone matter. We need to think and we need to mobilize to understand why this is happening, why are laws constantly changing, and why is rich, abundant research never ever taken into consideration, because the trend is definitely downward. The speed is frightening. And I think we've been faced with a very grim reality that there's no bottom to this pit. Every time we think we've reached the worst, something else happens and something further happens. I don't have the solution to this question. I think if I did, I would probably be somewhere else, sipping a martini. But I think in addition to our thinking and in addition to our ongoing research, we probably need to throw in this element. Thanks so much, as ever.
Thank you very much.
And finally, so thank you all very much for attending, Violeta for helping with this event, for the speakers for coming, and Elspeth, thank you very much for being here with us today.
And thanks to all of you for coming. This is, and all of you online for being here. This has been an extraordinarily rich and interesting discussion. And to the co-hosts, thank you very, very much for your support. And we will continue to provide you with our support as well.
Thank you.
Thank you. Is there somebody waiting for